Okay, we're back on the record in case 18 CF 492. We're outside the presence of the jury. The defendant, Mr. Wiley, is again present with his counsel, Mr. Nelson, Mr. Barnard, on behalf of the people. Prior to bringing the jury back in the room, I had admonished the gallery just a few minutes ago, but there are additional people, many more additional people in the gallery now. It is going to be our policy, ladies and gentlemen, that there will be no one exiting or entering the courtroom during the closing arguments. So if any of you cannot abide by that, I would advise you to exit now. The other admonition that had been given, and I'll give it again, is during the closing arguments, there will be tolerated no verbal or physical gestures or reaction to anything that's being said. Again, if you don't believe you can abide by that admonition, I would advise you to leave now. If any such reaction occurs during the closing argument, the bailiff has been advised and will remove any person who has such a reaction. Okay, the clerk has now returned. Counsel, anything either one of you would like to raise before we summon the jury? Mr. Barnard?
No, Your Honor.
Mr. Nelson?
No, thank you.
Please have the jury. Good morning, ladies and gentlemen. I once again hope you had a very restful good night's sleep. We're back on the record, and we're still in the defense case. Mr. Nelson, does the defense wish to call another witness?
Your Honor, the defense rests.
Okay. And is there any rebuttal evidence on behalf of the people?
No, Your Honor.
Okay, ladies and gentlemen, you have now heard all of the evidence in this case, but the trial is not ended. At this time, the lawyers have the opportunity of making final arguments to you. First, the state will argue. Then the defense will argue. Then the state will have a chance to respond to the defense argument. The state has the opportunity to give the first argument and the last, not because of favoritism, but because they have the burden of proof, which is, as I previously stated to you, the burden to prove the defendant's guilt beyond a reasonable doubt. I must caution you that what the lawyers say during arguments is not evidence and should not be considered by you as evidence. If a lawyer makes a statement that is not based on the evidence or reasonable inferences to be drawn from the evidence, you should disregard the statement. You are to rely upon your own recollection of the evidence. After you've heard the arguments, I'll instruct you on the law, and then you will retire to the jury room to consider your verdicts. With that, Mr. Barnard, you may make an argument.
Thank you, Judge. Your Honor, Judge Atterbury, Mr. Nelson, ladies and gentlemen of the jury. It is hard to decide which is sillier on its face. The notion that phones do things all by themselves, or that an infant can be suffering from pneumonia for a period of time without displaying the slightest of symptoms, particularly when those closest to her had eyes on her for that time. A perfectly happy and healthy 2-month and 3-week-old infant. Travis Wiley and Dr. Jane Turner met at the intersection of deceit and desperation, Travis Wiley, and denialism, Jane Turner. Let us take a look at the Travis Wiley part of that equation first. He had been up all night. Some 900 internet clicks between midnight and 10:30 a.m. That's almost 100 an hour. And when Christina Dunford leaves for work, she puts her in Travis Wiley's care, where she spends the last 4 hours of her functional life alone with him. Now, Travis Wiley says he took a nap at about 1:30, and as we know, claims that he woke up 45 minutes to an hour later to find Ariana lifeless, blue, not breathing. When we look at all of the information in front of us, I think that putting all of that together, particularly the timeline shown by the data, we can reasonably figure out he took a nap. All right. But it wasn't at 1:30, because we know that he was on his phone from 1:30 to 2:30. That phone went silent at 11:17 a.m. and was silent until 1:30 that afternoon. But before that phone went silent, what do we know? The last contact, the last activity on that phone was Travis Wiley connecting to a news story about a man who had been charged and convicted of murdering a 3-year-old child. Now, Travis Wiley would say, and did say, a number of things. But we know that the things he said were not true. We know when he said he took a nap, I was sleeping from 1:30 to 2:15 or 2:30. It wasn't true. We know it's not true. We don't know, only he knows, when he shook that baby and effectively killed her. When we put everything together, I think the most reasonable scenario is that when mom leaves for work at 10:30 in the morning, Travis Wiley, who's been up all night, all over the internet, probably tired, fatigued, and little Ariana likely did what babies do and cried, maybe fussed. Whatever it was too much for him to tolerate. fatigued, frustrated. The most likely scenario is when she left, he grabbed that baby and shook it out of frustration and fatigue, put the baby down when the baby essentially stopped, not because it had returned to a calm state, but because it was now unconscious. What else would explain that? Internet contact at 11:17. Of all the things we can imagine, all of the information, the data on the internet, everything that's out there, endless. He goes there. And then the phone goes silent for 2 hours. The most reasonable scenario as to when is that when that baby goes limp, he puts the baby down in the rock and play and assumes everything is going to be just fine. 2 hours later, 2 hours and 15 minutes later, we know he's awake. We know he's awake. He's on the phone again and continues to be on that phone from 1:30 till 2:30. At about 2:30, he knew that he could no longer ignore the condition, the appearance of little Ariana. Now, he claimed, as you have heard Detective Towdy relate to you from his conversations, that he then called 911 and couldn't get through. Well, he got on the phone all right, but the first thing he does is he makes 3 calls to a woman by the name of Melissa Enning. Then he gets around to calling Burger King and then Christina's phone. Now, it's pretty clear that when you make 7 phone calls in 7 minutes, he knew something was terribly wrong, and it was. But 911 was not this guy's first move. Think about it. He had at least an hour or in that neighborhood. Maybe not quite an hour. But he had time to figure out, what am I going to say? What am I going to do? And this may not be a big thing, but it may be a big thing. He calls Burger King, finally gets through to Christina, finally gets a hold of Mom, and tells her, got to come home. Ariana's not breathing. What's she say to him? Have you called 911? No response. She says she didn't give him the chance. In fairness, she hung that phone up. She called 911 on her way home, and that's how 911 got involved. Here's that little thing that may be a big thing. Remember what Christina said she saw when she got there? Remember? He's standing out on the street, smoking a cigarette. This 2-month-old child is laying inside of that house on death's door, and he's standing out on the street smoking a cigarette. What does that tell us? That's for you to decide. There are two very important things that happened after that afternoon, after that night, when it comes to the behavior of the defendant, Travis Wiley. The first one happened about 5 months later, in May, when there was a phone conversation that was secretly recorded, authorized by the court to be recorded, when Alyssa Donnelly engages the defendant in conversation about what happened on January 20th. Now, there are a number of ways to process that, to think about what it means, what he said, but I'm going to suggest to you one of them, and it's this. I'm going to put it in the form of a multiple choice question, and let's take a look at that question and the options. What would be, when you don't know you're being recorded, the least likely thing that an innocent person would say when asked about this horrific tragedy and his involvement in it? What do you think the least likely thing an innocent person would say? An innocent person would say. The least likely thing. Would it be, I want to help all I can? No, that's pretty consistent with what an innocent person would say. How about, I feel really bad about the family. I think an innocent person would and could say something like that. How's about, you know what? I need to help the police sort this thing out. I think an innocent person might or could say something like that. Or, I got to get out of this town. Where I'm going, there is no extradition. Which of those is the least likely thing an innocent person would say? It's what he said. And there is one more fact that emerges, actually three of them, from the conversation that took place between Detective Towdy and the defendant when the defendant was arrested and was interviewed on June 30th. On June 30th, Detective Towdy interviewed the defendant. And he questions him again about what happened on January 20th. And by this time, of course, Detective Towdy has the information from the phone extraction, right? And he says to the defendant, Travis, I know what you said, but you were all over that phone between 1:30 and 2:30, and it's right here. What was his response? Excuse me. What was his response? Remember? Phones do things all by themselves. All the time. No, they don't. That data, that extraction, that activity came from his phone. It originated from his phone. Then Detective Towdy closes in and he says to him, you know, Travis, you weren't sleeping from 1:30 to 2:30. What's the defendant say? Phones do things all by themselves all the time. One more time, he presses. Travis, you know, that internet contact at 11:17, you know, that's a problem, Travis. What does he say? Phones do things all by themselves all the time. Now, when we put all of that information together, those answers, what we know from the phone, what he said to Alyssa Donnelly, the timeline, you know, we got to ask ourselves, boy, that's a bad collection of coincidences, isn't it? Well, I'm going to suggest to you that if all of that is just a coincidence, then Travis Wiley needed to be on the cover of the January 2018 issue of Bad Luck magazine. Not only that, he deserved a bronze statue in front of the Bad Luck Hall of Fame. But we know this was not a coincidence. We know this was not a coincidence. One of the things that the judge is going to tell you, one of the things among the instructions that he's going to share with you, I'm going to call it, well, it's called the circumstantial evidence instruction. I'm going to call it the Travis Wiley instruction, okay? What the judge will tell you, among other things, is this. Circumstantial evidence is the proof of facts or circumstances which give rise to a reasonable inference of other facts which tend to show the guilt or the innocence of the defendant. Circumstantial evidence should be considered by you together with all the other evidence in the case in arriving at your verdict. I'm going to guess, in fact, I'm going to bet that when I sit down, you are going to be treated to the notion that, well, Travis Wiley was crying when the police got there, and he was upset. And Kevin Towdy told you that. There's no doubt about that. But, you know, I think medical doctors would describe it this way. They would describe it as a nonspecific symptom. What do I mean by that? Well, no doubt he was crying. No doubt he was upset. But why? He just succeeded in bringing the life of a 2-month-old child to an end. And he was staring down the barrel at his life changing forever. So when you hear that, I would suggest to you that you ask yourselves, what was the real reason he was upset? He was looking into the future. And what about Jane Turner? Let us turn now to Jane Turner. I think it is apparent from what we learned yesterday afternoon, it took a while to unmask the real belief system of Jane Turner. Jane Turner struggled mightily, first of all, to avoid answering a simple question, a series of simple questions. Do those words appear in your report? Do those words appear in the medical records? Show me where those words are. And I'm not sure she ever answered that question without giving all of us an editorial, an evasive editorial. The contortions she went through to avoid answering those questions were spectacular. The gymnastics that she went through to try to dodge a simple question, a series of simple questions, the only other place you're going to see those kind of gymnastics is in the Olympics. Jane Turner was in a jam, and she knew it when the questions started. She knew you could tell that, saying this infant had pneumonia was going to be a problem for her, based on what everybody else saw, up close and personal with little Ariana. I mean, anyone who has ever known anyone else, anyone who's ever had pneumonia themselves, know what the torture of pneumonia is. The symptoms that you show. Coughing, difficulty breathing, fever. It is not fun. And it is obvious as can be. Jane Turner knew that part of her diagnosis was a problem for her. Likewise, sepsis. When asked where that diagnosis, even an impression or even a suspicion appears in the medical records of Blessing Hospital or Cardinal Glennon, contortions. I'm going to call it light switch sepsis. That's her diagnosis. Turn it on, out of the blue. That's not how sepsis works. Infection. She was a big fan of explaining, well, this child clearly had an infection. Well, I'm not, given the short amount of time, I don't know that Blessing Hospital would have had the opportunity to work that up and diagnose it. But Cardinal Glennon Hospital, a children's hospital, where infants are brought from all over the Midwest for specialized care and treatment, armed with emergency medicine physicians, radiology, neurology, infectious disease physicians, trauma specialists. And you remember what their findings were when laid in front of Dr. Turner were? No evident infectious disease to explain this infant's decompensation. She put in a report, DIC, remember that? DIC, diffuse intravascular coagulation. That was a big part of this infant's collapse, according to Jane Turner. But when confronted with what Cardinal Glennon's records say, remember what that was? Mild coagulopathy. Addressed at Cardinal Glennon, not only improved, but was resolved. You know, that doesn't fit very well, does it? With her progression. And then we get to CSVT and stroke. Again, when asked, Dr. Turner, can you show us where that diagnosis appears in Cardinal Glennon's records? How about an impression? Even a suspicion? Nothing. Stroke, the immediate primary cause of death. That's going to be for the autopsy, folks. And what did we learn there? You remember? Stroke has a very different presentation. It is focal, a narrow area. This infant's subdural space beneath the dura was filled with blood, and you saw the pictures. Everywhere. Not just underneath the dura, but underneath that very thin membrane over the brain, the arachnoid membrane. Doesn't fit. Again, a small moment that may mean lots. Dr. Williams, remember what he said about an infectious process like pneumonia? What are you going to see? And what did he look at? And what did he not see when he looked at it? The lymph nodes. If you've got an infection, I don't care if it's pneumonia, bacterial, viral, whatever it is, your lymph nodes are going to be swollen, enlarged. What do we see? What do you find? Zip. Nothing. And on top of all of that, she's got to deal with the weight as appeared in that consensus statement of the American Society of Pediatric Neurology, Pediatric Radiology, American Society of Pediatrics, the European equivalents of those same specialties, all of whom came together and issued that consensus statement. She's got a problem. How do you get around that? If you're Jane Turner, what am I going to do? Wait, I know. I'll put some slides up there. That'll look good. That's, we can talk about slides. We can go through a bunch of slides, and we can point out this, that, and the other thing, and maybe that'll work. It was as if all of those associations, those physician specialty associations who came together and to remind their fellow practitioners, abusive head trauma is real. Abusive head trauma has classic signs. Abusive head trauma involves subdural hematoma in almost every case, and very specific kinds of injuries to the retina. Not all injuries to the retina, not all retinal hemorrhage is the same. There are specific kinds of retinal injury that are classic, specific for abusive head trauma as a result of shaking. But it was more than that, what they said, and that came through Dr. Petrak. Remember, I'm going to read it to you because, as I read it to her, because I couldn't do it on my own. Remember when she was asked to disagree and did agree with the notion that the defense in cases like this, where shaking is the mechanism, the defense will argue that shaking an infant cannot cause serious injury. And they will bring in opinion testimony provided by a small group of medical witnesses who have offered, ready for this, scientific sounding critique of abusive head trauma diagnosis by offering other explanations like CSVT. Here's the problem. You remember what came out of that consensus? You remember? That problem is this, that based on that consensus, that accumulated experience of study, clinical practice, treatment, that there is no reliable medical evidence that CSVT can cause the collection of injuries associated with abusive head trauma where shaking is the mechanism. It was as if they were warning us about people like Jane Turner. And that still begs a question, at least in my mind. This question about Jane Turner. Remember she said that, there was a time in her career where she had, as a medical examiner in St. Louis, diagnosed closed head injury somewhere between 2 and 3 dozen times in children that caused their death. But she turned, didn't she? She went another direction. Why? Why? Well, we may not know all of the reasons, but we know one of them. We know one of them. In the last number of years, after diagnosing all of the tragic events that caused the death of 2 to 3 dozen children that she came to the conclusion resulted from homicide, Virchow Consulting came to that conclusion. None. Well, maybe according to her, once. Once. Cash is the lubricant for her conclusions. Okay? Let's just get right to it. Now, as long as there are abusers who injure and kill children by their abuse, there will be Jane Turners. She's poised. She's ready. She will parachute in, offer an opinion, scoop up the cash, and get down the road to the next courthouse. You know what? It is reasonable to conclude that if the money is right, Jane Turner would tell us that somebody that gets shot and killed, died from natural causes. Lead poisoning. If the money is there. And I'm not so sure. Well, in fact, I think it's reasonable to conclude from what we've heard that Jane Turner may have only one report. In two other cases very recently, and those are just the ones we know about, she has arrived at the identical conclusion in the face of charges of abuse that resulted in the deaths of children, where she concluded that this is a natural cause. This was an infection followed by sepsis and DIC that created or caused CSVT and a stroke, and the baby died. Marcus Mays, the fellow, that's the one around here. The main case, within the last 6 months. Same case, only the names are different. Only the names change. And that brings us to another thing you're going to hear from the judge, another instruction. It's an instruction on the believability of witnesses. I'm going to call this the Jane Turner instruction. That instruction, which Judge Atterbury will give to you, reads like this: only you are the judges of the believability of the witnesses and the weight to be given to the testimony of each of them. In considering the testimony of any witness, you may take into account, his or her ability and opportunity to observe, his age, his memory, his manner while testifying, any interest they may have, any prejudice they may have, and the reasonableness of their testimony considered in light of all the evidence. Pneumonia, anyone? Infection, anyone? As I listened to Jane Turner over those hours in the late afternoon yesterday, it reminded me of something. Now, this next slide may cause you to ask, what does this have to do with anything? Maybe some do, maybe some don't, but I remember a time when there were doctors who would come in to court or in front of congressional committees and say, there is no evidence that smoking causes cancer or lung disease. No evidence whatsoever. Until we found out that their research that they relied upon. There's the research, the studies, the data shows there's no evidence that smoking causes cancer, until we learned that the research was sponsored and they were paid by the tobacco industry. Interest in the outcome is a thing you may and should, in this case, consider. Three physicians testified before you in the case before Dr. Turner took the stand. Two forensic pathologists who were there. They laid hands on the body of little Ariana, up close and personal and difficult. as well as an expert in the diagnosis and treatment of abuse of children. And what we learned from them is this was not a close call. You remember that? Remember what they said? This was not a close call. The signs and symptoms of abusive head trauma with shaking as the mechanism were as classic as they were horrifically tragic. And on a spectrum of either cause undetermined, or in this case, CSVT at one end and abusive head trauma on the other end, no doubt, this was not a close call. This was abusive head trauma. None. Sure, you heard from Jane Turner. But we learned a lot about Jane Turner and her mindset. She is a denier. She does not believe that shaking can cause injury or death to a defenseless infant. She doesn't believe it. But when she does so, she's swimming upstream against a massive mainstream and experience of specialists in this area who say her opinion, this CSVT progression, is bunk. If it looks like a duck, and it walks like a duck, and it quacks like a duck, it is a duck. Some might look at it differently, or say it differently. When you hear hoofbeats, think horses. Not zebras, especially if you're in Illinois. This is for you to decide. And I'm going to ask you to decide. I will return after Mr. Nelson has the opportunity to speak with you. And at that time, after my comments in response to his, again, I'm going to ask you to make a decision. Thank you, folks.
Thank you, Mr. Barnard. Mr. Nelson, you may argue.
Thank you, Your Honor. So on January 20th, Travis was so tired, so exhausted. Ariana was either crying or fussing. And because of that, Travis shook her to death. That's the state's theory. That's the state's case. That's a great story, except they've presented no evidence to show that Ariana was crying or fussing at that time. No neighbors were called to say that they heard that it had been going on for hours. And so, of course, Travis must have been super frustrated and give rise to that level of anger or stress or whatever you want to call it. But the state has presented absolutely no evidence in that regard. You're supposed to assume that. You're supposed to assume that even though the state says that he was constantly on his phone, that he was so frustrated with Ariana that he decided to shake her to death instead of make a call. A call to Christina, a call to somebody else, hey, come and help me out. What we do know is that on January 20th, Christina Engel received a phone call that every parent fears ever receiving. That there was something terribly wrong with her precious child. Travis was immediately talked to. That only makes sense. I mean, he was the one who was caring for Ariana. He was the one in whose company she became unresponsive. So it only makes sense that the police would want to talk to him and obtain as much information as they can about what happened, get his account. But they did more than that. They also characterized that residence as a crime scene. But despite that, Travis was cooperative. He talked to the police. He handed over to the police a set of keys to the apartment. He handed over to the police his phone. He gave the police consent to search the apartment. He gave the police consent to search his phone. He talked to the police not just once, but multiple times. And every time that he talked to the police, his account of what happened was unwavering. It was consistent. I will tell you that police detectives, when they interrogate suspects, they're looking for any little inconsistency, any little discrepancy. It's a common tactic. You interview somebody more than once, you pick up on some little detail that either they didn't mention the second time or something that was just a little bit off. They'll capitalize on that. They'll make it a big deal. And I can guarantee you that if that happened in this case, you would have heard about those inconsistencies. But the police also talked to Christina Engel. And she told Detective Eddie that in the days leading up to January 20th, yeah, Ariana was fussier. In fact, on that very day, January 20th, Christina felt warmer. And critically, days before this, Ariana had stopped breathing while in the care of Christina. Now, at some point after that, Christina downplayed each and every one of those things. But that was what she told Detective Eddie. The autopsy was conducted because the police believed that this was a suspicious death. We all know what conclusion Dr. Williams, Dr. Scantlebury came to. But it's important to note that they came to those conclusions in the absence of any evidence of any bruising any external injury to the body at all, in the absence of any cervical spine injury, this is a case where the state is telling you that little Ariana was shaken so vigorously that her brain shifted inside of her skull and caused significant hemorrhaging to various parts of her brain, her eyes, the optic nerve sheath, and yet there was no injury to her spine. Her neck muscles are still developing. She can't hold her neck, and that's the state's theory. But if she couldn't hold her neck, if she didn't have those muscles, and she's being shaken that hard, why would there not be spinal injury? I do want to pause here because when Dr. Scantlebury was testifying, she said something that was very significant. I asked Dr. Scantlebury, what was the mechanism of injury? You remember what she said? She said, I don't know. My next question to her was, so you're not certain the injury was caused by shaking? And her answer, I would not go that far into making that declaration, no. The state's own witness told you that she can't be certain that Ariana was shaken. You also heard from Dr. Jane Turner. Dr. Turner, MD, PhD. Dr. Turner, who has consulted both with defense attorneys and prosecutors. Dr. Turner, who was herself a former medical examiner. She told you, she explained to you how the medical record in this case was lacking. She told you why that was significant. The same medical record on which Dr. Williams relied and on which Dr. Scantlebury relied and on which Dr. Petrak relied. She told you how that medical record contained certain findings, but the lab results that gave rise to those findings were not in that record. She told you how the entire discussion could have been informed had there been additional cultures taken at the time of the autopsy. And Dr. Turner told you, in fact, she showed you in slide after slide, how there was an ongoing process of clotting that was occurring in Ariana. And not that it just started, but that it had to have been occurring for some period of time. She told you and she showed you how there were processes going on in these clots that demonstrated that some of them were in the process of healing. Some of them were in the process of being broken down. Those things happen over time. The state could have recalled their experts to reinterpret those slides for you. The state could have called their experts to explain how Dr. Turner's interpretation of those slides was not correct. But instead, the state suggests to you today that, oh, the defense is just throwing up slides to just kind of make this look like something that it's not.
Mr. Nelson, I'm sorry to interrupt. I've been informed that there's somewhat of a medical emergency on behalf of the jury, so I think we're going to take about a 10-minute break. And I know this is unusual, but I've been signaled by one of the jurors that they're having somewhat of an emergency, so I think we need to take a break right at the moment. I'm going to allow them to exit the room. Ladies and gentlemen, I will again advise you that this is not the time to begin your deliberations. That time has not yet arrived. Please don't talk among yourselves about the case, communicate with anyone else about the case, do any research via any means about the case. This is unusual, I understand, but I wouldn't be doing it if I didn't believe there was an emergency. So at this time, we're going to take a recess.
All rise.
Okay, the record should reflect that all 12 members of the jury are back in the courtroom, along with the 3 alternate jurors. Mr. Nelson, you may continue your argument.
Thank you. And you saw, ladies and gentlemen, I think it was People's Exhibit number 18. And I pointed to the screen and I asked Dr. Turner, what is this? Her answer to you was, that's a blood clot. Much has been made of this consensus statement, which was signed on to by a number of different types of professionals. But for which is noticeably absent the pathologist's community. Pathologists, Dr. Turner told us, were not a part of that consensus statement. Pathologists like Dr. Williams, who's a pathologist. Pathologists like Dr. Scantlebury, who's a pathologist. In fact, Dr. Turner told you that the National Association of Medical Examiners at one point in time had a position paper on pediatric head trauma and homicide, and that there no longer is a position paper by pathologists on that topic, and that that very fact is indicative of the position of pathologists as a broad community on this topic. Ladies and gentlemen, Ariana's death was the result, a tragic result, of natural processes. Travis did not murder Ariana. The state has not proven beyond a reasonable doubt that Travis murdered Ariana. And we are asking you to find Travis not guilty. Thank you.
Thank you, Mr. Nelson. Mr. Barner, you may make a rebuttal argument.
Thank you, Judge. Ladies and gentlemen, a couple of thoughts. Boiled down to its essence, Jane Turner says they all missed it, every single one. Blessing missed it.
Cardinal Glennon and every specialist within that campus missed it. Pathologists who were there, who looked into Ariana's body, missed it. Only I can find it. The defendant does not have to produce any evidence anytime. But when you, as has just been suggested to you, come in and you say, well, you know, the American Society of Forensic Pathology says this, and there's a position paper on that. You know, it'd kind of be nice to maybe hear about it, read it, or at least have someone read from it. Because now what we're left with is Jane Turner's word for it. Excuse me, I think I'm supposed to turn my mic on. My apologies. So, what we do know is that her go-to theory from one case to another is her CSVT progression thoroughly and massively and consistently refuted as being junk science. This position paper was not issued, vetted, reviewed because it was a slow day for that community. When they said there is no support for this theory, the CSVT theory, they meant it. Doctors rely on that. It just happens to be that Jane Turner is in denial. Again, we don't know all of the reasons why. Well, except for one. At best, it is painfully obvious, not only from her demeanor while testifying, but from the medical literature. At best, she is blinded by her belief system. And that's fine. And that's fine. But please, Dr. Turner, do not make Ariana your victim. I recall among the things that Mr. Nelson said about what Dr. Turner said, particularly, I'm going to suggest to you that you give some attention to why it was Dr. Turner was not bothered by the inconsistency that Detective Towdy confronted Travis Wiley with. Doesn't that kind of bother you that, you know, this key component that I went to bed, I took a nap, everything was fine, and I wake up and she's dead? Doesn't it bother you even a little bit that it's clear that that story isn't true? Not even a little bit? Nope. She might as well have just said, that's my story and I'm sticking to it. She might as well have just said that. She's got her theory. CSVT does all of this stuff. Forget what all the medical records and all the medical science says. This is my theory. Infection, sepsis, DIC, CSVT, and stroke. That's her riff, to me anyway, on the house that Jack built. Except we'll call it the house that Jane built. It is a house of cards. A house of cards. You know, these things do not happen in public. They do not happen in public. And when, for whatever reason, a person cannot admit it to themselves or others, in the minds of people like Jane Turner, that means it didn't happen. But again, we know how silly that is. Likewise, as Dr. Petrak shared with you and affirmed from the consensus document, you do not see cervical injuries in shaken baby cases all the time. And you cannot rule it out because it's not there. You may find it. You may not. Children, infants, are a challenge. Don't we know it? Infants can tax your patience to the max. But parents, most of them anyway, unfortunately. But parents know there's a line. Parents know there's a line that you do not cross. Others, as here, not so much. This infant will not see a birthday or a diploma or a family dinner. That is sad enough. But let us not compound it with junk offered for cash, for money, by a defendant who would deploy her as a shield. We have been operating this system for about 1,000 years. Comes from England. Somewhere around 1100, those folks over there decided, there are some decisions that are too important to be made by the king. One of those decisions is the kind of decision you are about to be asked to make. That our peers, our community, our neighbors are the ones who should have that responsibility. That is your responsibility today. My job is finished. Yours is not. I am going to ask you, taking into consideration all of the things we have shared with you, that you make a decision in the form of a verdict for the sake of the evidence, for the sake of justice, for the sake of Ariana. I'm asking you to return a verdict of guilty. Thank you.
Thank you, Mr. Barnard. Okay, ladies and gentlemen, the arguments and evidence are all completed. I'm ready to now instruct you on the law. Because you are going to receive the complete instructions when you go back to deliberate, I don't believe you'll need to take extensive notes while I'm reading to you. Members of the jury, the evidence and arguments in this case have been completed, and I'll now instruct you as to the law. The law that applies to this case is stated in these instructions, and it is your duty to follow all of them. You must not single out certain instructions and disregard others. When I use the word he in these instructions, I mean a male or a female. It is your duty to determine the facts and to determine them only from the evidence in this case. You are to apply the law to the facts and in this way decide the case. You are not to concern yourself with possible punishment or sentence for the offense charged during your deliberation. It is the function of the trial judge to determine the sentence should there be a verdict of guilty. Neither sympathy nor prejudice should influence you. You should not be biased in favor of or against any person because of that person's race, ethnicity, national ancestry, religion, gender, sexual orientation, age, disability, or socioeconomic status. From time to time, it's been the duty of the court to rule on the admissibility of evidence. You should not concern yourself with the reasons for those rulings. You should disregard questions and exhibits which were withdrawn or to which objections were sustained. Any evidence that was received for a limited purpose should not be considered by you for any other purpose. You should disregard testimony and exhibits which the court has refused or stricken. The evidence which you should consider consists only of the testimony of the witnesses and the exhibits which the court has received. You should consider all the evidence in the light of your own observations and experience in life. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, others we might not be fully aware of, which is why they're called implicit biases or unconscious biases. Our biases often affect how we act, favorably or unfavorably, toward someone. Biases can also affect our thoughts, how we remember, what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you're being asked to make important decisions in this case. You must resist jumping to conclusions based on personal likes or dislikes. You must not let bias, prejudice, or public opinion, influence your decision. Neither by these instructions nor by any ruling or remark which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Faithful performance by you of your duties as jurors is vital to the administration of justice. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of and others we might not be fully aware of, which is why they are called implicit biases or unconscious biases. Our biases often affect how we act favorably or unfavorably toward someone. Biases can affect our thoughts, how we remember, what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make important decisions in this case. You must resist jumping to conclusions based on personal likes or dislikes. You must not let bias, prejudice, or public opinion influence your decision. You must not be biased in favor of or against any person because of his or her race, ethnicity, national ancestry, religion, gender, sexual orientation, age, disability, or socioeconomic status. Your verdict must be based solely on the evidence presented. Those of you who took notes during trial may use your notes to refresh your memory during jury deliberations. Each juror should rely on his or her recollection of the evidence. Just because a juror has taken notes does not necessarily mean that his or her recollection of the evidence is any better or more accurate than the recollection of a juror who did not take notes. When you are discharged from further service in this case, your notes will be collected by the deputy and destroyed. Throughout that process, your notes will remain confidential and no one will be allowed to see them. Opening statements are made by attorneys to acquaint you with the facts they expect to prove. Closing arguments are made by the attorneys to discuss the facts and circumstances in the case and should be confined to the evidence and to reasonable inferences to be drawn from the evidence. Neither opening statement nor closing arguments are evidence, and any statement or argument made by the attorneys which is not based on the evidence should be disregarded. Only you are the judges of the believability of the witnesses and of the weight to be given to the testimony of each of them. In considering the testimony of any witness, you may take into account his ability and opportunity to observe, his memory, his manner while testifying, any interest, bias, or prejudice he may have, and the reasonableness of his testimony considered in the light of all the evidence in the case. Circumstantial evidence is the proof of facts or circumstances which give rise to a reasonable inference of other facts, which tend to show the guilt or innocence of the defendant. Circumstantial evidence should be considered by you together with all the other evidence in the case in arriving at your verdict. The believability of a witness may be challenged by evidence that on some former occasion he made a statement or acted in a manner that was not consistent with his testimony in this case. Evidence of this kind ordinarily may be considered by you only for the limited purpose of deciding the weight to be given the testimony you heard from the witness in the courtroom. However, you may consider a witness's earlier inconsistent statement as evidence without this limitation when the statement was made under oath at a hearing, or the statement narrates, describes, or explains an event or condition the witness had personal knowledge of, and the statement was accurately recorded by a tape recorder, videotape recording, or a similar electronic means of sound recording. It is for you to determine whether the witness made the earlier statement, and if so, what weight should be given to that statement. In determining the weight to be given an earlier statement, you should consider all the circumstances under which it was made. You have before you evidence that the defendant made statements relating to the offense charged in the indictment. It is for you to determine whether the defendant made the statements, and if so, what weight should be given to those statements. In determining the weight to be given to a statement, you should consider all the circumstances under which it was made. The fact that the defendant did not testify must not be considered by you in any way in arriving at your verdict. The charge against the defendant in this case is contained in a document called the indictment. This document is the formal method of charging the defendant and placing the defendant on trial. It is not any evidence against the defendant. The defendant is presumed to be innocent of the charges against him. This presumption remains with him throughout every stage of the trial and during your deliberations on the verdict, and is not overcome unless from all the evidence in this case you are convinced beyond a reasonable doubt that he is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to prove his innocence. The defendant is charged with the offense of first-degree murder. The defendant has pleaded not guilty. A person commits the offense of first-degree murder when he kills an individual if, in performing the acts which cause the death, he knows such acts create a strong probability of death or great bodily harm to that individual. To sustain the charge of first-degree murder, the state must prove the following propositions. First proposition, that the defendant performed the acts which caused the death of A.H., a minor whose initials are A.H. Second proposition, that when the defendant did so, he knew his acts created a strong probability of death or great bodily harm to A.H. If you find from your consideration of all the evidence that each one of these propositions has been proved beyond a reasonable doubt, you should find the defendant guilty. If you find from your consideration of all the evidence that any one of these propositions has not been proved beyond a reasonable doubt, you should find the defendant not guilty. When you retire to the jury room, you first will elect one of your members as your foreperson. He or she will preside during your deliberations on your verdict. Your agreement on a verdict must be unanimous. Your verdict must be in writing and signed by all of you, including your foreperson. The defendant is charged with the offense of first-degree murder. You will receive two forms of verdict. You will be provided with both a not guilty and a guilty form of verdict. From these two verdict forms, you should select the one verdict form that reflects your verdict and sign it as I have stated. Do not write on the other verdict form. Sign only one verdict form. You will be given both of those verdict forms. Okay, that concludes the instructions on the law. I will now ask the clerk to swear the bailiffs, who will then escort you, the jury, back to the jury room.